How's it going, everyone? Geronimo Gutierrez here, back with you from Poseidon Defense A.P.C, your favorite criminal defense law firm in Orange County. Today we're going to go over California DUI checkpoints, your rights and what to do. Just imagine you're driving home late at night, minding your own business, and then you see them, right? Flashing lights, cones, a line of cars. You've just entered a California DUI checkpoint. Your heart starts racing. Do you know your rights? Do you know what to say, what to do, or what not to do to protect yourself from a potential DUI arrest? I'm Geronimo Gutierrez, Chief Counsel of Poseidon Defense A.P.C, your dedicated criminal defense law firm in Fullerton, California. Today we're demystifying California DUI checkpoints, what they are, what police can and cannot do, and your absolute critical rights to protect yourself if you find yourself in a California DUI checkpoint. In California, DUI checkpoints are legal, but they must follow a strict guidelines. They are usually announced in advance, involve a systematic, and it's crucial, systematic stopping of cars and aim to detect impaired drivers. However, your constitutional rights still apply. And I say systematic with emphasis because it has to avoid some random subjective random belief or approach from the officers. It has to be systematic. Let's say every 2 cars, they're gonna just, regardless, they're gonna tell them to pull to the side and ask them some questions. Police can stop you briefly to check for sobriety, but they cannot simply detain you indefinitely or search your vehicle without probable cause. Understanding this distinction is key. Here is your step-by-step guide on how to handle a California DUI checkpoint while protecting your rights. First, be prepared before you even get there, right? Have your driver's license, registration, and proof of insurance readily accessible. Keep your hands visible on the steering wheel as you approach. I just always have my driver's license, registration, proof of insurance. Just put a paper clip and put it in a place in your glove box or wherever you want it to be convenient. So you can just quickly hand it to the officer. Number 2, provide required documentation. When asked, provide your driver's license, registration, and proof of insurance. You are legally required to do this. 3, invoke your right to remain silent. If an officer asks questions like, where are you coming from? Have you been drinking tonight? Politely but firmly state something like, I invoke my Fifth Amendment right to remain silent. I'm not discussing my day. Just be cool about it. Don't engage in conversation beyond providing your documents. Now, refusing field sobriety tests, commonly known as FSTs. Officers will often ask you to perform field sobriety tests, like walking a straight line or standing on one leg. Politely state, I do not consent to any field sobriety tests. These tests are voluntary and designed to be tricky, definitely. Refuse preliminary alcohol screening tests, PAS tests. It's voluntary. There's a catch to that, and I'll address that soon. This is a handheld breathalyzer. If you are not on probation for a DUI or under 21, this is a voluntary test. Politely state, I do not consent to a preliminary alcohol screening test, pass test. Be aware that refusing this may give the officer probable cause to arrest you if other signs of impairment exist, right? It's kind of a whole totality of the circumstances they like to use. Do not consent to searches. Do not consent to searches. If an officer asks to search your vehicle, politely and clearly state, I do not consent to any searches. They need probable cause or a search warrant to search your car. Do not argue or physically resist if they search anyway, which has even happened to me. But your verbal refusal is critical. Excuse me. Many people worry about refusing tests. There's a critical distinction. California has an implied consent law, but it applies after a lawful arrest for DUI. Let's start with pre-arrest refusals for field sobriety or preliminary alcohol screening. Refusing the test before arrest, if not on DUI probation nor under 21, is your right. While refusal alone cannot be used as evidence of guilt in court, it can give an officer more reason to believe you are impaired and lead to an arrest based on other observations that they have. Moving on to post-arrest refusals, whether it be blood, breath, urine, you are lawfully arrested. If you are lawfully arrested for DUI, California's implied consent law means you must submit to a chemical test. Blood or breath usually is what happens. Refusing a post-arrest test has severe consequences. Automatic 1-year license suspension by the DMV, and it can be used against you in court. What I do like to do with that, though, is some judges will, depending on your record, really, some judges will entertain the idea of having the suspension run concurrent with any suspension that the court might impose, so that way you had already essentially been punished with suspension and can use a credit that you've already had to do through the DMV suspension. If, despite your best efforts, you are arrested at a DUI checkpoint, your very next step is vital, right? If you're at the arrest point, you got to contact a DUI defense attorney in Fullerton immediately. A few details. A DMV hearing, there's a 10-day rule. You have only 10 days from your arrest to request a DMV administrative per se A.P.C hearing to fight your license suspension. Missing this deadline means automatic suspension. Building your defense, an attorney can challenge, right, the probable cause for your stop, the field sobriety tests, the breathalyzers, calibration, blood test accuracy, and more. A DUI conviction carries severe penalties. It can. Fines, jail time, license suspension, increased insurance costs, permanent criminal record. Your attorney fights to minimize or eliminate these consequences. A DUI checkpoint encounter can be, scary, frightening, but being informed about your rights is your strongest defense. Remember, politely invoke your rights and never hesitate to contact legal counsel. If you or a loved one has been arrested for a DUI at a checkpoint in Orange County, LA County, surrounding counties, or anywhere really in California, don't wait. Contact Poseidon Defense immediately for a confidential consultation. We're here to protect your right, your driving privileges, and your future. Just a follow-up really on the refusals of tests. Under California law, individuals generally have the right to refuse a preliminary alcohol screening test or field sobriety test before an arrest, provided they are not under 21 or on DUI probation, right? This is actually explicitly recognized under California Vehicle Code 23612, which requires law enforcement officers to inform individuals of their right to refuse a preliminary alcohol screening test before administering the test. The statute states that the officer must advise the individual of their right to refuse the test. Does it happen? Not all the time. Let's just say that. In People v. Jackson, the court emphasized the legislature granted individuals the statutory right to refuse a test and required law enforcement to inform the individuals of this right. The court further held that evidence of a refusal to take a test cannot be used to establish consciousness of guilt, as doing so would undermine the statutory right to refuse, right? Again, that's People v. Jackson. However, there are exceptions. And I want to just go through this again because it can be a little nuanced. There are exceptions to this general rule. For individuals under the age of 21, the California Vehicle Code 23136 establishes a zero tolerance policy, deeming that any person under 21 who drives a motor vehicle is considered to have given implied consent to a preliminary alcohol screening test or other chemical test if lawfully detained. Refusal to submit to such testing will result in suspension or revocation of the individual's driving privilege for a period of 1 to 3 years. Similarly, and that's also under Vehicle Code, California Vehicle Code 23136. Similarly, individuals on DUI probation are subject to stricter requirements and may face license suspension for refusing a preliminary alcohol screening test pursuant to California Vehicle Code 13353.1. For individuals not under 21 or on DUI probation, refusal to take a preliminary alcohol screening test or field sobriety test before an arrest does not in itself result in suspension of a driver's license. License suspension under California Vehicle Code 13353 is triggered only when an individual refuses to submit a chemical test, blood, breath, or urine, after a lawful arrest for driving under the influence, cited in California Vehicle Code 13353. The implied consent law applies post-arrest and does not extend to pre-arrest tests or screenings, field sobriety tests for individuals outside the mentioned exceptions. In conclusion, the individuals who are not under 21 or on DUI probation, refusing preliminary alcohol screening tests or field sobriety tests before arrest is their statutory right and should not result in a suspension of their driver's license. This principle is supported by both statutory provisions and case law interpretations. Again, all under California Vehicle Code 23612, People v. Jackson, Cal App 4th 1461, California Vehicle Code 23136, and California Vehicle Code 13353. So just a little bit more detail on that. Hope it helped. If this video armed you with vital knowledge, please hit that like button, subscribe to our channel for more essential California criminal defense insights, and ring that notification bell. And please share your questions below. We're here to help you understand your options. Or even send us a private message if it's, a little bit too personal. Don't want it shared out there on the interweb. Again, good to be back. You can reach us at 714-978-9988, 714-978-9988. Give us a call, text us, email Poseidon Defense Law@gmail.com, and have a great week.